Recording in progress.
I would like to call to order the Richland County Development and Service Committee meeting for September the 27th, 2022 at 5 p.m. Madam Clerk, could you please call the roll?
Malinowski.
Here.
Wait, I'm on the wrong one.
We just talked about that upstairs.
Hugh.
Here.
Horatio.
Here.
Barron.
Here.
English.
Present.
Newton.
Here.
We have a quorum.
We move on to item 2. That's approval of the minutes from regular session meeting we had on July the 26th, 2022.
Move to approve.
Any discussions, any deletions or changes? Nope. With that being said, Madam Clerk, please call the roll. Call for the vote, I'm sorry.
Pugh.
Yes.
Horatio.
Yes.
Barron.
Yes.
English.
Yes.
Newton.
Yes.
Motion approved.
Thank you, ma'am. Item number 3 on the agenda is adoption of the agenda for September 27th. Can I get a motion?
Move to approve. Second.
Changes?
No, sir.
Madam Clerk, please call for the vote.
Pugh.
Yes.
Horatio.
Yes.
Barron.
Yes.
English.
Yes.
Newton.
Yes.
Motion approved.
Thank you, ma'am. Item number 4 on our agenda, items for action, the Community Planning and Development, Conservation, Historical Columbia Heritage, Tourism Marketing Plan. You can find that on page 10 through 14.
Mr. Chair,
You recognize Ms. Barron?
I'd like to move to approve this item. Second.
Have a motion and a second. Is there any discussion? Madam Clerk, please call for the vote.
Pugh.
Yes.
Horatio.
Yes.
English.
Yes.
Newton.
Yes.
Motion approved.
Thank you.
Barron.
Recognize.
Absolutely.
Motion approved.
All right. We move to item number 5 on the agenda, items for discussion. Item 5A, I move to direct the county administrator to work with the county attorney to research and draft an absentee landlord ordinance. The ordinance should provide potential remedies for individuals who violate the county's ordinance and provide, provide via supplementary documentation to a comprehensive review for legal impacts associated with adopting such ordinance. Administrator, this item has been in committee for about 2 years. I talked with Ms. earlier today, and we want to know exactly where we are or what we need to do to kind of move this forward so we can get it to General Counsel.
Understood. I'm going to have ACA Jensen, Mr. Chair, address that item for you.
Mr. Jensen, you recognize, sir.
Thank you, Mr. Chair. Much appreciated. ACA Jensen for the record. What you have before you today is a proposal from staff for an administrative process to register the owners of property that are occupied by people or individuals other than themselves, what we just colloquially call absentee landlords. That system would be free of charge for the individuals, with the exception, unless they have more than a certain number of units, they would then be required to obtain a business license. That would, what we anticipate is that this information will allow us to more quickly address issues because we will have a database of contacts, both local and of ownership, in case there is a situation arises. Accompanying that, we also have an ordinance that has been prepared by the county attorney's office, which clarifies a couple different points. In particular, it discusses or codifies the concept that any party who is part of whatever the issue is can also be part of the remedy in the sense that a property owner, a property manager, and the tenant may all be involved in whatever instances are occurring on the property that are creating the nuisance that we are investigating. So the recommendation of the staff is one, that you direct the administrator to move forward with the procedures regarding creating a database and registration system for absentee landlords, and that also that you recommend to council the draft ordinance language that is in front of you. In addition to that, as the staff, we have internally discussed a much broader concept, which is civil penalties versus, lacking the word here, other types of penalties, criminal penalties. That is a very strong program that is taking place in other communities that has proved to be very profitable, very successful. It takes a lot of time to put that kind of a program together. But both Deputy Attorney McLean and I have discussed this, and we would like to, in the future, recommend that council and staff look at that as another potential way to address the issues that we have. And that is my report, Mr. Chair.
Thank you, Mr. Recognize Ms. Barron.
Thank you, Mr. Chair. I do have a couple of questions for you, ACA Jensen. This database is only going to be comprised of absentee landlords, or will it also include landlords in general? And the reason why I asked this, in several of the communities in my district, that's a challenge. You have renters that are there at the property, but a lot of the actions that are needed to be taken have to be taken by the property owner, but they don't know who to contact for the property. So I would, if it doesn't, I would like to, maybe we can expand. Definitely we want to capture the absentee landlords, but landlords in general, if we had their information, that would be helpful as well.
Yes.
You're recognized. I'm sorry, I apologize. Go ahead.
Oh, thank you, Mr. Chair. May I respond?
Yes, sir.
Thank you, sir. Again, ACA Jensen for the record. Yes, the answer is this is specifically for all situations where the owner does not reside on the property. So in any situation where, we as staff have to go in, or as code enforcement have to go in and address an issue, and the property owner is not present, we want to know who that property owner is and how to contact them. So it would address all those situations.
Mr. Chair, I do have another question.
Go ahead, Ms. Barron, you still have the floor.
And so in the vein of that, will this be public information that HOAs and community organizations would be able to tap into the database for their use in their community?
Mr. Chair, yes,
Sir.
thank you. I'm not sure how to answer that yet because I would have to I'd have to work with the county attorney's office to know to what degree this would be public information. My initial response is, I believe so. I believe it would be public information in the sense that if they made a request to know who is the manager of this property or so forth, that it would be. But I will have to confirm with the county attorney's office that is the case.
Thank you, Mr. Chair.
I would think that this database will be created for our use to be able to look this information up once we identify someone as being a nuisance. I don't know if we want to create a database and put ownership of these properties out to the public, and their neighbors that live next to their rental properties are calling them and harassing them. I don't know if we want to go that route. But Ms. Newton, let me recognize Mr. Newton, and then Mr. Attorney, you got it.
If you would like Mr. Wright to address some of those points, I'm happy to wait to ask my questions.
All right, you recognize.
I just wanted to say that, yeah, we have to check into it, but it is very possible that if we create anything that we create like that could potentially be considered public information. So probably likely the owner would definitely, I'm pretty sure, actually, be public. All their information, we'd have to check into it, but it's possible.
Ms. Newton, you recognize.
A different question that I was going to ask. Don't we, as a follow-up, don't we have a certain amount of property records and ownership records that is already available now? If you log into GIS, you can pull up a plat, see the owner, the last assessed value, who represents them at every level of elected office. So is there a way that this would be considered different?
That's correct. All property you can look up basically and find out who owns it through the clerk of court or through the different processes, to be honest. So yeah, most of that information is already available in public information. It's just that for situations for us, just to make sure that all the information is current and don't have to go through the process of publishing and doing things like that, this is simpler.
Understood. So then in terms of the questions that I have two sets of questions. I have some questions that are legal questions about the ordinance, and then I have some questions that are process questions in terms of how we would implement them. So let me just start with the actual ordinances drafted, if I may. So my first question is looking at 16-72, item A4, which says if the owner shall not reside within 50 miles of the registered address, then all of the above information is also required of an authorized agent residing within, I'm presuming, the 50-mile radius. And I guess I was wondering if you could explain to me how that works. Does that mean that if I live in Florida and own a property here, that I have to find some person to register? And what is the thinking behind that?
Yeah, absolutely. The point is so that there's someone local that can deal with situations that come up, because it can be difficult to get in contact with someone, an owner that lives in Florida or California or wherever, so that they're required to have some individual is an authorized agent within 50 miles that can be contacted if there's a situation that comes up.
And would that be considered, I guess, an undue burden? Because again, if you can reach me wherever it is that I live, if I owned a property in Omaha, I mean, I don't know that I know anyone out there that I would trust to be an agent on behalf of my property.
No, to be honest, it's actually common practice.
Okay.
And the very purpose of it is so that if there are situations that come up, and for service purposes, of like if someone is a lawsuit or different things, they're required to have that authorized agent. So that's something that's already required by a lot of entities already.
Okay. And then my next question is, as I look on page 19 at the last paragraph that precedes section 2, severability, right before that, it says, in addition to the appropriate civil and or equitable remedies for the enforcement of this article, any person convicted of violating this section shall be guilty of a misdemeanor and shall be punished in accordance with the provisions of section 1-8 of this code of ordinances. So a few questions on that. We have established that as part of this ordinance, we are creating responsibility among tenants, property owners, and potentially property managers for violations. My question is there an order of operations in terms of who is held responsible for an item, or is it all individuals equally at all times? For example, if someone's grass is 25 feet, do we start by saying renter redress this problem, then property manager redress this problem, then owner redress this problem? Or do we say all y'all fix it now and all y'all will be fined now if you don't do what you're supposed to do? Was that question clear?
I think it depends on what the violation or issue is, because the thought is that, say, if something that's a zoning issue or maybe building regulation, that the tenant may not have anything to do with it, so the owner would be responsible. And it says in there that unless there's affirmative evidence to show that the tenant actively constructed something or created the violation, the use violation. So it just depends on what it is. Like the example you gave as far as grass, I think that could depend on what the lease actually says, whether the owner is responsible or whether the tenant is responsible. So it just depends on what the violation is and what the facts show. And the whole point is a lot of regulations have the owner responsible. So you can't even give a citation to the tenant, which is difficult if the owner is 50 miles away or, like in another state, for example. So what this does is allow you to cite the tenant, even if the owner lives in California.
So then, and I may be asking this incorrectly, are you saying that whoever is offering the citation has a great deal of latitude to determine who is cited based on the law in some parts and judgment on other parts?
I think the citation itself, if you have would generally be with the authorized agent if someone's 50 miles away. If you're within that 50-mile radius, then you can cite, the tenant, the property owner, potentially the property, depending on the situation. But it allows you to do that because there's some responsibility for any of them. So if you just said the owner, then we can never cite the tenant, for example.
And I know Mr. Malinowski wants to ask a clarifying question. I have one more. I'm just want to.
I wanted to just clarify something you were asking.
Okay, sure, because I wasn't clear yet. So.
All right, it's at the bottom of, Mr. Chair.
Yes, sir.
Thank you. It's at the bottom of page 18 where it says 16-73 Enforcement and Penalties. It says right there, this is for all y'all deal. It shall be the responsibility of the owner, property manager, property management company, and tenant, each individually and collectively, to comply with all county ordinances related to maintenance. So I think there's your answer.
And I just think that we're getting too far in the weeds trying to figure out if the penalty goes to the renter or it goes to the homeowner. The name of the ordinance is the absentee landlord ordinance, which means that responsibility should go to the landlord, that person who owns the property. I think as a governmental entity, if we get too deep in the weeds about enforcing rules with renters, we don't know what the rental contract says. I think we just need to keep it basic and across the top. Go ahead, Ms. Newton.
Well, I guess from my perspective, one of the things that I intended as a maker of the motion, and I don't need to necessarily read everybody's lease, is normally what happens right now is that you go to the person who is allowing the grass to grow. And so because this establishes collective penalties, I do think it's important to understand who you're going to, because quite frankly, if the tenant is handling their business and mowing their grass or not parking junk cars in the front yard, then we never have to go to talk to anybody. But I'll see what Mr. Wright wanted to respond.
No, I think that as it is now, generally the owner of the property is responsible. So what that does is that we do have property where the owner may, like you said, live in Florida or California, and sometimes it can be difficult to serve them with anything. And so it's hard to actually enforce anything because if you can't serve the tenant, you may never get the person who lives in California.
Right. Gotcha. So my last question about this ordinance, besides my process questions, but I'll pause after this in case others want to talk, is something that's not in this ordinance, and I'm not sure if we're allowed to do it. Frequently at the county, we have situations where property owners will let the grass grow, have things turn into semi-blight, et cetera, and you create situations where Richland County goes to remediate the problem. We mow the grass. We remove the things that were illegally dumped when their last tenants moved out. We incur costs, both financially and in terms of time, to remedy a problem that is actually the responsibility of another party. And you can say, there's no way to fit it in here. I just want to ask, do we have any opportunities to redress for the county in terms of recurring some of these costs where there are properties that we've been mowing for years, that the owner's not taking responsibility for?
There are some potential remedies. Part is putting a lien, but that kind of only takes effect when, if the property is sold or something like that. So that's that's the problem you run into, is that if the owner doesn't do something, ultimately the only way to do it is to find a way to recoup it. And there's certain things you can't, for example, put on the tax roll, like when for their bill, for example. So that's where you fall into, how do you get them to pay? You can ticket them. And unless you do the criminal penalty, the only way is you can do a lien, but it may be years before you see anything, if ever.
May I repeat that back to you? Are you saying that currently the only options that we have at the county to potentially be compensated for the effort that we're putting in is a lien, which goes into effect only when the property is sold, or a fine, or I'm sorry, not a civil penalty, but a criminal penalty? Can you just repeat that? I just want to make sure I understand.
Yes, a lien or a criminal penalty, where it's basically a fine or something like that.
We can't just send them a bill and say, hey, it costs us $400 a month to cut your grass.
Sure, you can send them a bill, but you're not getting money by sending the bill.
Sure. Okay. Thank you. I have other questions, but I'll defer until other people get to ask theirs. Thank you.
Ma'am. Mr. Jensen.
Thank you, Mr. Chair. If I may speak to that matter,
Yes.
This last session, Deputy Attorney Ziegler and I actually had a bill floated before the legislature that unfortunately died in committee, that would give the county the ability to actually place these liens on the tax roll and have them collected in the next tax year when they came due. We had bipartisan support for the bill. We're going to bring it back. This time, it was such a short notice that we did not have time to educate and to get a campaign together. But we are working on that to come back before the next session. Cities have that ability. Counties do not here in South Carolina. So we are hoping and trying to do it. Again, we got support. We had the bill was put forward. We had, I want to say 12, 13 different members signed on to it. It just happened too late and didn't get to committee or didn't get through committee, but we plan to do that again.
All right.
And
Thank you,
that's,
Mr.
and that's the thing, is that it would take a change in state law to allow that to happen.
Mm-hmm.
Thank you, sir. Councilwoman English.
Most of my question.
Aaron.
Yes, I just, to that point, ACA Jensen, please, as you all move forward, and I know Administrator Brown, he keeps us abreast of what we need to rally behind. But if you will, when this item goes forward, to please let us know so that we can help to push this forward, because it would be I think it would be a great win, not only for Richland County, but, counties across the board, because this is not just a personal problem for us here, but in other counties.
Yes, ma'am.
I would like to recognize the Honorable Bill Malinowski, and then Ms. Newton, could you please finish asking your questions?
Thank you, Mr. Chair. And Mr. ACA Jensen, I'm just putting these questions out there so they can come back as answered at the next meeting. You don't have to answer them now. One of the items, I don't know where the distance of 50 miles came from, because certainly I could live in the extreme northwest of the county and own something in the extreme southeast, and it would exceed 50 miles. So maybe we need to indicate or live within the county that if you own property. The other one I had questioned was, it says in here, and this is on page 16 under the background, that you would require, and it may be in that ordinance, require a business license for any person or entity that owns 2 or more non-owner occupied residential units. Is an apartment complex considered one unit, or is each apartment in there considered a separate unit? And if I then live in the apartment complex, am I absolved from all of these rules because I'm living in the complex itself? What is the cost to create this database you're referring to? I believe Ms. Newton already, or somebody referred to the penalties. And while it does say civil over here, and then it says and or equitable remedies, and then it says shall be guilty of a misdemeanor. I kind of thought misdemeanor was criminal. So maybe we need to say appropriate civil or criminal remedies if that's the case. You did say this, and I thought you were referring to this, ACA Jensen, that this type of program was profitable. I'd like to know if you could give us some information on how that works out. And then, is this only for absentee landlords or all landlords? I don't understand why all landlords wouldn't have to have a business license, and why it has to be 2 or more. Certainly loopholes get created when laws get created. And if I've got a family with 2 or 3 children and all say teenagers, I can have 5 units, put one in the spouse's name, one in each of the 3 kids' names, one in my name, make them all owners, and bingo, I bypass most of these rules and regulations. So I think we need to maybe tighten something up on that. And then as far as the enforcement and penalties, where I just read to Ms. Newton what was listed down there, certainly if I'm a tenant and I'm renting from you, ACA Jensen, and I'm paying you the rent, I'm not going to believe I'm required to go out and mow the lawn or cut the weeds. Okay, so I'm not going to be concerned about that. And I don't think that we should have tenant in here. I believe, as was mentioned, that it should be the responsibility of the actual, as Chairman Pugh was saying, it's the landlord ordinance, not the tenant or someone else. So that's kind of all I have for today. Thank you.
All right. Thank you, Mr. Malinowski.
Mr. Chair.
Yes, sir.
I can answer some of those questions today. Some I will have to come back with.
Yep.
By profitable simply means feasible, functional, it works.
Oh, Mr. Jensen, this is going to stay in committee, so if you can get those answers and then just have
Oh,
them
yeah.
at our
Okay.
next
I can do
meeting,
that for
would
you.
be
Yes,
great.
sir. I'll do that all of them.
Ms. Newton, would you like to add?
Did Ms. English have a question? If so, I would like to defer to other people to have time to ask questions.
My only concern is like you were talking about earlier with the landlord tenant agreement and not getting into the weeds. And just making sure, unless it's stated in that agreement, that this is the responsibility of the landlord.
Thank you, ma'am. Ratio.
I just want to say, like you said, this is a long time coming, and and the spirit of it has, the beginnings of it, I think, has come from some frustration, not just with one council district, but with several, and for kind of several different reasons. But I think this is a really, really good work that you all have done, and I appreciate everything we've done, from having big meetings, including lots of people, to smaller meetings, and really trying to get something that's going to serve folks in Richland County. So just want to say thank you.
I would like to also piggyback off of Councilwoman Terracio. What we do have to understand is that Richland County, Columbia, is considered almost like a transient town. We have a lot of people that come and go, from the military base to people, the institutions of higher learning. And we all see the effects of absentee landlords in our districts. And as Mr. Malinowski said, and a few other of my colleagues, it's very important that we get this right the first time and not develop something and push it out and it has multiple loopholes in it. And then we are right back at the drawing board later because we're trying to revamp it and figure out how we can fill those loopholes. Any more discussion? Yes, ma'am. Ms. Newton.
Thank you. My final questions, and these are questions that you can bring back and speak to us, because they don't directly address the ordinance, but I'm just curious to know if thought has been given in terms of how we would go about educating landlords about this process, because certainly someone who becomes a landlord tomorrow, well, they may or may not know, but most people right now are operating in an environment where they don't have to register. And again, that's not something that I need to have answered right now, but will be critical in terms of the success of the implementation of the ordinance.
For discussion? Okay, all right. Let's look at item number 6. Items pending analysis with no action required. 6A, move to direct the county administrator to evaluate current zoning laws that permit zoning designations for large residential developments to remain in perpetuity and present options to reevaluate or rezone those properties if they're not developed within 7 years. Recommendations should include processes to ensure that zoning and comprehensive plans remain consistent with the lived character of the community. Those items are pending recommendation from the Planning Commission. Is there any discussion with any of those items? If not, we'll go to 6B. 6B, I move to direct the county administrator to conduct a review of the rank weed vegetation ordinance that recommended an update that would improve the effectiveness of the ordinance, particularly as it relates to safety, enforcement, and blight reduction. The appropriate department will prepare a discussion that will be before us on October the 25th. Ms. Newton, you're recognized. Thank you.
Mr. Administrator, I know that there will be staff conversations about this, but I would also just like to request that there be an opportunity to include me in a meeting. And I know that I've talked to Chief Polis at the Sheriff's Department. They have expressed interest in this, as well as Councilwoman McBride, if we could be part of those formative discussions.
Ma'am.
Discussion? Okay, let's move to 6C. Based on the below information, no further action should be taken by the Planning Commission or Council related to the new land code development, related to the land development code until urban heat island map is completed. The expansion of residential, commercial, and transportation infrastructure contributes to the areas where temperatures are much warmer and that could put people at risk for injury or death on hot days. I asked that Mr. Quentin Epps come down and just give us a brief overview of the heat islands for those that are paying attention to our meeting that didn't have an opportunity to get an agenda where the explanation is in the agenda, the information provided with the agenda. Mr. Epps, you recognize, sir.
Mr. Chair and members of the committee, Quentin Epps, Conservation Division. In brief, heat islands are areas which are much hotter than surrounding areas, in some cases as much as 12 degrees. These areas are formed when vegetation is replaced by asphalt and concrete because these surfaces absorb the heat from the sun instead of reflecting the heat like vegetation does. The heat mapping project under discussion is designed to identify areas of the city and county which are hotter as well as areas which are not hot. From this, we can better plan to increase vegetation in the mapped hot areas and maintain vegetation in the mapped not so hot areas. And just briefly again, hopefully that answers your questions. If you have any questions, I'll be glad to try to answer them.
Do you have any more questions or discussion?
Mr. Chair.
Yes, sir. Mr. Wright, you recognize?
My only concern is that I don't think that council can direct the planning commission not to consider something before them, that they're required by statute to consider certain things, and they can make recommendations to council. Ultimately, council doesn't have to do certain things, but I don't think council can direct the planning commission not to consider something that's before them.
For discussion? What I would like to say, I would like for us to move diligently to figure out if we need to send this to another committee or what needs to happen with the planning commission. As my colleague, Mr. Malinowski, has authored this motion, we would like to see it at least move before his retirement. Yes, sir. You recognize Mr. Malinowski.
Thank you, Mr. Chair. I don't know if it'd be proper here that the motion could be amended so that it doesn't use the word direct, but present to the planning commission for their input.
Yes, things can be, presented to planning commission for their consideration, but yeah, can't direct them to not.
Right. So then that's why I would, reword that section.
And you recognize.
Thank you, Mr. Chair. So if I hear you correctly, in order for us to fix what's here or before us, we need to make an amendment through a motion. Make an amendment to the thinking plot.
Right.
Is that correct?
Yes. It needs to be changed from, instead of directing the planning commission to take no action, to it can be brought before planning commission to consider the heat islands.
Am I hearing a motion from the floor?
Yes. I'd like to make a motion to make the amendment to this existing motion as our attorney has just stated.
No.
Well, I'm amending the existing motion.
Second.
I'm not clear.
It's clear. My understanding is that you're amending the motion to utilize the language provided by the county attorney to move this item to the planning commission via a presentation for consideration by that body. That's my understanding of the motion that was made.
It was properly amended and second. Any more discussion? Madam Clerk, please call for the vote.
Pugh,
Yes.
Teratio,
Yes.
Barron,
Yes.
English,
Yes.
Newton.
Yes.
Motion approved.
Thank you. This brings us to item number 7. Is there a motion for adjournment?
Move to adjourn.
Second.
It's been properly moved, seconded. Madam Clerk, can you call the vote, please? Yes.
Barron,
Yes.
Teratio,
Yes.
English,
Yes.
Newton.
Yes.
Motion approved.